and you try to understand, is this a place where, given the nature of the place, its function, its restrictions on access, that weapons are out of place? And if so, that's probably a sensitive place where the state can say.
But I think what the Chief Justice is trying to do is figure out how those cash out in the real world. So I'll give you a few more. New York City subways.
So, I think that the question of whether you could restrict arms in the subways, you'd have to go through the analysis, I think, and say, is there restriction on access generally, I suppose?
No, I got the analysis, all three parts of it. Like, how does it cash out? What does it mean?
I don't know how those are going to cash out in particular cases, because I think the way that you would normally deal with that is you'd look at all the briefing we had in this case on the history of these various things. And so, on behalf of my individual clients, I suppose I could give away the subway because they're not looking to go, they're not in Manhattan, they're in Rensselaer County.
Started with universities, and you said that would be all right. Did you mean that?
Yeah, yes, I did mean that.
Because that's open for, anybody can walk around the NYU campus.
Well, NYU doesn't have much of a campus.
I would go back to New York, and I think you'll find that that's wrong. Similarly, the Columbia campus.
Columbia's got a campus, and I don't know whether they restrict access at all. And maybe if they don't restrict access to parts of the campus, maybe those are parts of the campus where they wouldn't enforce the policy anyways. The point I'm trying to make,
but you can't say there are 50,000 people in one place, a ballpark. There are 50,000 people in one place. They're all on top of each other. We don't want guns there. That's you couldn't. The city or the state couldn't do that.
I think they might well be able to, because again, you can't get into Yankee Stadium without a ticket. I'd have to understand many of these. I don't know every jurisdiction. I don't know enough about Yankee Stadium. But, a lot of these stadiums are not run by the government anyway, so if a private entity wants to restrict access, I don't know where the state action is for the...
Suppose the state says no protest or event that has more than 10,000 people.
I think that might be, trickier. Maybe they could justify that under strict scrutiny, but I don't think that would be a sensitive places.
But why not? I mean, I guess it's about the level of generality. All these questions that Justice Kagan's asking you or that the Chief asked you, if you concede, as I think the historical record requires you to, that states did outlaw guns in sensitive places, can't we just say Times Square on New Year's Eve is a sensitive place because now we've seen, people are on top of each other, we've had experience with violence, so we're making the judgment. It's a sensitive place.
So here's what I would suggest, that the right way to think about limiting guns in Times Square on New Year's Eve is not as a sensitive place, but as a time, place, and manner restriction. And that might be a perfectly reasonable time, place, and manner restriction. But I don't think that's the sensitive places doctrine as I understood it from, and obviously it's a brief reference in the Heller decision, so I may not fully understand it. But I understood that those were certain places where there were just no weapon zones all of the time because of the nature of that institution. And I think it's probably worth thinking about rallies and Times Square. There may be restrictions, but they would be done under the rubric of time, place, and manner.
Could we start with the purpose of the personal right to keep and bear arms? And the core purpose of that right, putting aside the military aspect, is self-defense. So starting with that, could we analyze the sensitive place question by asking whether this is a place where the state has taken alternative means to safeguard those who frequent that place. If it's a place like a courthouse, for example, a government building where everybody has to go through a magnetometer and there are security officials there, that would qualify as a sensitive place. Now, that doesn't provide a mechanical answer to every question, and but would that be a way of beginning to analyze this?
Justice Alito, that might be a way of analyzing it. The reason I'm a little bit reluctant to go that route as opposed to really think about the nature of the place and the restrictions that are associated with its core activity is because I worry that if you went that direction, then the state would say, well, this part of the city, we have a lot of police officers, and so you really don't need to exercise your own individual self-defense right there because we have your back. And I don't think that's...
I don't know what those places would be, but... Continue.
Well, I think my friends would tell you that, the whole city of New York is that way. And I think there are a lot of people in New York, and New York may have a lot of reasons to have regulations that are a little bit different than in upstate New York where my individual petitioners reside. But I don't think that they can take all those people in New York and deny them of their fundamental constitutional rights.
How do we do this?
Justice Breyer?
How? I mean, so far we've been, to my mind, I think NYU does have a campus. You're not certain. All right? You think that in New York City, people should have considerable freedom to carry concealed weapons. I think that people of good moral character who start drinking a lot and who may be there for a football game or some kind of soccer game can get pretty angry at each other. And if they each have a concealed weapon, who knows? And there are plenty of statistics in these briefs to show there are some people who do know. And a lot of people end up dead. Okay? So, what are we supposed to do? To sort of float around, like with NYU, and say, hey, this is the rule. It seems to work out in upstate New York. We don't know, of course, and we do know that your client is carrying a concealed weapon because he has a right to, in some instances, and even following Heller. And following the history, which I thought was wrong. Even so, what are we supposed to say, in your opinion, that is going to be clear enough that we will not produce a kind of gun-related chaos?
So, Justice Breyer, I would sort of point you to two things that maybe would give you some comfort. I mean, one is the experience of the 43 states, and there are amicus briefs on both sides getting into the empirical evidence, but there really isn't the case that those 43 states that include very large cities like Phoenix, like Houston, like Chicago, they have not had demonstrably worse problems with this than the 5 or 6 states that have the regime that New York has. So that's one place to look. The other place that I think you would find something persuasive there is their own amicus brief on their side by the city of Chicago. Because the city of Chicago is in a shall-issue jurisdiction. And the city of Chicago goes on to sort of, essentially brag about all of the ways that they've done consistent with that regime to reduce crime in Chicago that probably doesn't have a direct analog in downstate Illinois. But of course, one of the problems with this case...
I mean, most people think that Chicago is like the world's worst city with respect to gun violence, Mr. Clement.
Chicago and their corporate...
Chicago doesn't think that, but everybody else thinks it about Chicago.
And nobody thinks that about Phoenix, and nobody thinks that about Houston, and nobody thinks that about Dallas, and nobody thinks that about San Diego, which, even though it's in a restricted state, is a shall-issue jurisdiction.
Thank you, Mr. Clement. Justice Thomas, anything further?
Mr. Clement, where does Mr. Nash live?
Mr. Nash lives in Rensselaer County, New York.
Is that close to NYU?
That is nowhere near NYU, Justice Thomas. And I think if you look at the county website, they talk about their 153,000 people spread over 955 square miles. And yet that's the context in which my individual clients are being denied their Second Amendment rights.
Justice Breyer, anything further? Justice Alito? Justice Sotomayor?
Counselor, your client is permitted to, Mr. Nash, one of the two, to carry when engaged in outdoor activities of any kind, like camping, hunting, and fishing on back roads, with the few substantially lesser number of people. Tell me how many places in Rensselaer County does your client have a self-defense risk? I mean, at what point do we look at the restriction and the burden it places? Meaning, yes, I'm sure it has a center of town. I'm sure it may have a shopping center or two. But it's not like he's totally restricted from carrying a gun. He's just restricted from carrying one basically in those sensitive places. Because the rest of his home is pretty distant from other homes.
So, Justice Sotomayor, just so we start on the same wavelength or the same page, literally page 41 of the joint appendix, this tells Mr. Nash where he can carry concealed. And what the officer, McNally, told him was, quote, I emphasize that the restrictions are intended to prohibit, italicized, you from carrying concealed in any location, all caps, any location, typically open to and frequented by the general public. Now, I would submit that's a pretty broad number of places in Rensselaer County, and it would include, I fear, most of the roads in the county at night when you're traveling and might think that you have a need. I mean, if Mr. Nash has a relative whose car breaks down and has to have a change of tire and he wants to go out and assist them with that and wants to make sure that he is in a position to defend himself, I don't think he can do it consistent with this license restriction. And at the end of the day, I think what it means to give somebody a constitutional right is that they don't have to satisfy a government official that they have a really good need to exercise it or they face atypical risks.
Justice Kagan, anything further?
Mr. Clement, you said, I think in passing, that it would be fine if New York banned open carry so long as it allowed concealed carry. Is that correct?
Certainly that's consistent with the relief we're looking for. We're looking for some outlet to exercise our constitutional right to carry firearms outside the home.
How is it consistent with the history? I mean, the history seems very clear to me that it's sort of like the exact opposite of how we think about it now. In other words, that there are lots of places that wanted people to display their arms as a matter of transparency, and what they prohibited was the concealed carry. So I'm thinking, like, if you look to the history, you end up with a completely different set of rules from the ones that you're suggesting with respect to concealed versus open. And it's an example, I think, of the difficulties of looking to history, where people were operating on such different, to use your term, wavelengths.
So, Justice Kagan, first of all, I would have thought that, we'd sort of cross the bridge to use history in this context in Heller. But if we're going to look to history, I actually think
Mr. Clement, the question is how to use history. And, where do you look? How far do you look? Do you look to the 1920s when all these felon laws were passed, as well as public purpose laws of exactly the same kind as New York? So one question is, how far up do you look? Another question is, with what sense of flexibility do you look? And I think that this is an example of that. It's like, no, we're not going to ask for an exact analog because we realize that the world has changed and regulatory schemes are very different because regulatory interests are very different. If we tried to copy history, we would find ourselves in a world in which the only thing that a state could do is tell people, you can't carry it concealed, you have to carry it open.
So, Justice Kagan, let me give you an example of how I think the court should use history in this context. And I'll go exactly to the Georgia statute that was at issue in Nunn against Georgia. Now, that was a statute that on its face prohibited carrying simpliciter. So it didn't say open, it didn't say concealed. Now, the court that analyzed that reversed, vacated the indictment of somebody under the statute because the statute didn't specify and they didn't think that person had carried concealed. But when they looked at it, they interpreted it in light of the context at the time, and they thought, boy, it is not consistent with the Second Amendment that that court actually thought directly applied to the state, which is interesting. But they said that's not consistent with the Second Amendment to prohibit any means for carrying. then consistent with kind of the norms of the time, kind of almost as like a severability holding, dare I say it, they said, well, all right, the open carry, that's allowed. I mean, rather, that's we're going to say that to the extent this statute prohibits open carry, that's unconstitutional, but to the extent that it prohibits concealed carry, that's constitutional. Now, the fundamental problem with the law that carries over as a direct analogy is it gave no outlet to exercise the constitutional right to carry for self-defense. The norms of the time had a favoring for open carry over concealed. I will grant you that the norms of the time have flipped, and certainly in New York, based on the rest of their licensing regime, I assume that they would prefer that my clients carry concealed rather than openly. But I think that's the way you can use the history, and you can use it with some contextual sensitivity, but you cannot sort of, throw it all out, because I do think the analogy is pretty clean between a law that prohibits any form of carry and what New York is doing here. And of course, that was one of the laws that this court specifically looked to in the Heller decision as well.
And when you look at this history in the properly contextual way, do you see no difference between the kind of regulation that was allowed in the home and the kind of regulation that was allowed in public places? Because it seems to me that the history, and Justice Sotomayor developed it at some length, but the history is replete with that distinction. And indeed, Heller recognizes that. Heller recognizes that the home is a very special place, both because, for similar reasons for the Fourth Amendment, but also because the need for self-defense is so much greater there.
So I think in terms of, I'm not going to tell you that the context doesn't matter at all. I mean, take sensitive places law, right? They don't really affect the keep right the way that they affect the carry right, unless you try to say the entirety of Manhattan is a sensitive place, and then they might affect both. But in general, the analysis is going to be slightly different. But I would say that, I don't think those differences are material here. I think if the district, instead of just banning handguns inside the home, had adapted a permitting regime that required district residents to show that they had an atypical need to possess a handgun inside the home, I'm not sure anything in Heller would have been different, because it's just inconsistent with a constitutional right to either ban the exercise of it or say that it's a privilege that you can only exercise if you show that you are atypical from the rest of the people who are equally protected by the constitutional right.
Thank you.
Mr. Cland, are you able to hear me?
Loud and clear.
Great. Some of your amici have asked us to provide further guidance to lower courts in cases beyond your own. And so putting aside your case for the moment, they pointed out that some lower courts have refused to apply the history test, for example, and said they will not extend Heller outside the home until this court does. Other courts have applied intermediate scrutiny and variations of that. Some have suggested that strict scrutiny would be appropriate to treat this right comparably to other rights under our modern tiers of scrutiny. I'd just be curious what views you have about all that.
Thank you, Justice Gorsuch. I think we would start with the idea that text, history, and tradition is an appropriate way to deal with this right. That's what the court said in Heller. I think this court would allow the court to make clear that the same analysis applies outside of the home. And I think this case, like Heller, is such an outlier that the court wouldn't have to say too much more unless it wanted to. I think if it wanted to, though, it would already, I think, go a long way to correcting some of the mistakes in the lower court, to say that text, history, and tradition is the test, not part of the test, but the test inside and outside the home. And if this court prefers to go the level of scrutiny route, I would simply say two things. One, we would prefer strict scrutiny as being consistent with a fundamental constitutional right. But even if it's going to be intermediate scrutiny, probably the single most important thing to remind the lower courts is that intermediate scrutiny requires narrow tailoring. And a law like this that takes a person who has no proclivity whatsoever, unlike the surety laws, to misuse firearms, and says you simply can't carry them for self-defense anywhere frequented by the public because you haven't demonstrated an atypical need. I mean, that's about as untailored a law as I can imagine. So I think if you did one of those two things, either make clear that it's text, history, and tradition outside the home as well as inside, or made clear that narrow tailoring is an integral component of the test, that would go a long way to clearing up some of the confusion in the lower courts.
I know you've had a substantial debate with your friends on the other side about the Statute of Northampton. We haven't heard about that today, and I just wanted to give you a chance.
Thank you, Justice Gorsuch. I'd say just a couple of quick things about the Statute of Northampton. First of all, I think that it was very clear from the Knight's case and the treatises that this court relied on in Heller that by the time of the framing of the English Bill of Rights, that was not a general prohibition on carrying outside the home, but was a prohibition on either carrying unusual and dangerous weapons or using common weapons in a way that terrorized the public. And so I don't think that that supports the other side's position here. And the second thing I would say is that probably the single most obvious point about the history is there just are no reported cases on this side of the Atlantic, not in actual reporters, not in newspaper reports about crimes of the day, that show anybody being prosecuted for a violation of the Northampton crime simply by carrying common firearms for self-defense. And the one U.S. early court that dealt with this, the common law equivalent of the statute, was State against Huntley in North Carolina, which was an opinion that was cited favorably in the majority opinion in Heller. And that case went out of its way to say that simply carrying firearms per se is not an offense. It's the intent to terrorize the people that is prohibited by Northampton.
Thank you.
Justice Kavanaugh?
Mr. Clement, I have several questions. First, I want to make sure I understand your main problem here with this permitting regime, as I understand it, is the discretion that's involved with the permitting officials, and your point that that's just not how we do constitutional rights, where we allow basic blanket discretion to grant or deny something for all sorts of reasons. But I understand you would not object or do not object to the regimes that are used in many of the other 42 states, the shall issue regimes. I mean, there could be particular problems with those, but I do not understand you to object to shall issue regimes. Is that accurate?
That's accurate, Justice Kavanaugh. And as you say, there are especially if you have something like good moral character, there is the possibility for discretionary abuse in those regimes as well. But the thrust of this case is, we'd like what they're having. We'd like what the people in the other 43 states are allowed to do and exercise their rights. And in many of those states, it's shall issue. And that is, of course, New York purports to have effectively a shall issue regime with respect to hunting. The only other caveat I wanted to add is it's the discretion combined with the atypicality requirement. So if they came up with some, sort of like magic wand that gave them a precise reading of typicality, and so there was no discretion, but the standard was still, at the end of the day, you have to show that you are atypical from the rest of the people protected by the Second Amendment. We would have a problem with that as well.
Right. A shall issue regime with an atypicality requirement would be no good in your view.
Exactly. Even if it could be somehow, if you could come up with some objective standard of typicality.
Okay. And the issue before us, as I understand it, is the permitting regime. We don't have to answer all the sensitive places questions in this case, some of which will be challenging, no doubt. Is that accurate?
That's 100% accurate, and it's sort of a market test of the accuracy of that, which is New York does have sensitive place laws, and we have not challenged them in this litigation.
And then to follow up on Justice Thomas's question and also Justice Gorsuch's, we should focus on American law and the text of the Constitution, and we don't start the analysis in a vacuum. But we start it with the text, which you say grants a right to carry, and then historical practice can